Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. And today we have Darin Wisehart here with us to talk about what happens to your car when you file a bankruptcy. Hey, Darin, how you doing today?
Great. I'm great. Things are moving right along today.
I like it. So, Darin, we've done several Facebook Lives, and you've been around a lot, and folks may not or may have seen you. So for the ones who haven't, can you just tell us real briefly a little bit about yourself?
So my name is Darin Wisehart. I'm I'm a bankruptcy attorney here at Pacific Cascade. Specialize in Chapter 7, Chapter 13 work, and I do some Chapter 11s every once in a while, do a little bit of tax work here and there, but mostly with the Chapter 13s, kind of focusing on helping people save their cars and reorganizing and getting back to where their debts are within reach. And with the Chapter 7s, obviously just the normal path of helping people get out of the debt that may have been chasing them for a long time.
I love it. This is going to be perfect. So today we're going to kind of talk about, your car, because we talked a little bit, and that's a major concern with most people who are going to file the bankruptcy. And so before we start, maybe we can just kind of go through a little bit on the general rule of, bankruptcy and property that a person owns, just, in general.
Mm-hmm. So looking at bankruptcy, anytime you look at bankruptcy, you want to make sure you understand that property needs to be protected in order to be kept. And so we always want to start a conversation with what exemptions are out there, what items are going to cover the value of your property so that you can keep the things that you want in the normal process of your life. That way on the ground, you don't have too many things change. Now in every state, there are protections when you file bankruptcy for a certain amount of items. So if we have a car, we're talking specifically about cars today, you're going to have an exemption for equity in your car in the balance around $4,000 per person that filed a bankruptcy. So that's usually your normal. Now we can talk all the other exemptions that are there. There's usually a lot of them. There's a house one, there's a, household goods and furniture. There's a lot of different categories. Today we're focusing on the vehicle aspect of it. So we want to make sure we're there, but usually around 4,000 in equity is going to be protected. Anything more than that, we're going to have to talk about either paying that value back to the creditors through the bankruptcy process, or handing the vehicle back and having it liquidated, sold, and then, having all the pieces fall back in place on that one.
Yeah. Well, if I'm filing a bankruptcy, can I just decide, well, I want to put this debt into bankruptcy, but I don't want to have my car debt be as part of the bankruptcy. Can they do that?
It's often a question is, I don't want to add my car to the bankruptcy, so I'm going to leave it out of the bankruptcy. Okay, that's the statement that's usually made. We want to always make sure we're clear that when you file bankruptcy is an all or nothing. When you deal with bankruptcy, Chapter 7 or 13, you're getting into the process to have everything be discussed at one point. Now, if you have an exemption for it, then you can protect it and keep it. It doesn't come into play. You may not lose it, but you still have to add the debt in. You have to talk about how you're going to deal with that debt. And then, of course, the secured creditor has to come in so that they can either protect their interests or represent themselves in this situation as well. And everything gets put in just the same. We just want to make sure that we know going in if we can keep it, and what, a lot of times what the goal is for the individual. What do you want to keep it? Do you not want to keep it? Where is the filer, your client, going to be on that situation?
You brought up a term, secured debt, and let's kind of get into that. But before that, it made me think, there's different ways people have cars, and does it make a difference in bankruptcy? For instance, what if you own your car outright? What if you're leasing it? Or what if you're still financing the vehicle? Does that make a difference?
It does. It's all different categories. So when we talk about leasing, the question is, do you want to assume the lease? Do you want to keep the lease? Are you current on it? And if you're not current, then you have to talk about possibly doing a Chapter 13 to keep the lease. So there's different roads when it comes to a lease. You can definitely keep it. Creditors, I'll say this a few times, creditors like money. They don't necessarily like vehicles. So If you want to keep the thing and you want to keep paying for it, then a lease it's okay to continue that. And with car loans, now we have a secured loan. Your lender is owed a certain dollar amount for that car before you have an equity interest in that car. And so that's what we're talking about when we talk about secured interests. We're talking about how much is that car loan. Say your car loan is $10,000. And let's say your car is worth $15,000. Well, you have $5,000 of equity in that car that's yours, as if you owned a $5,000 car, right? And the first $10,000 will have to go to the lender if it's sold, and then you would get the last $5,000. That's the idea of the secured interest, just to kind of give a little platform for that one.
So back to the car, then what choices are there? Any kinds of different options people have if they're filing a bankruptcy and they want to keep the car?
Mm-hmm. There's a lot of choices, and the biggest conversation that I often have is when you're looking to keep the car, you want to make sure that it's going to be a good car for you in the future. Of course, that's always your first conversation: is it driving well? Is it going to continue on? Is it going to run forever? Somebody might say, yeah, I got a Chevy Silverado and it's only got 80,000 miles on it. Those things ride forever. So you want to have that conversation about where they are with the vehicle and whether they want to keep it. Now, if they do want to keep it, most of the time you're going to be able to keep it. And there's a couple of offshoot conversations that we could have, for creditors that really got wily and wanted to retake the car. But if you're current on your vehicle going into a Chapter 7 or a Chapter 13, most of the time, if that's your one vehicle and you need to get A to B, you need to use that vehicle to get to work, you're probably going to be able to keep it. And that's, of course, you can't say for sure because every case is different. But at the same time, that's going to be a conversation with your attorney that you want to make sure that going into it, you have the idea that you can likely keep it for sure. In the Chapter 7, you would be going down a road after you file. The conversation is, are you current on the debt? And that would be a big conversation. If you're current on the debt, then you want to reaffirm the debt if you want to keep it. And of course, your three choices: reaffirm the debt, which is to keep on the loan, okay, keep going and keep everybody status quo. You can surrender the vehicle at that point. So you can hand it back to them and say, nah, the thing's not running so hot. I want to go ahead and, I want to cut with that car and maybe get a new car down the road. And so you'll surrender that car to them. And then you usually come up with arrangements to find a way to have them pick the car up or to drop the car off. Or you can redeem the car, which is to pay the value of that car at that point. In a Chapter 7, that doesn't come up so often. So we have a lighter conversation on that one because most of the time clients don't have the full value of the car to pay off the car right then. And that's usually what's necessary with a redemption.
So let's say I'd say, okay, I want to reaffirm the car. What are some things I should know?
So if you want to reaffirm the debt, the car, the first thing you want to make sure that that's the conversation. We walk backwards on that conversation of, is it a good car? Is it a car that you can make the payments on? Because we want to be sure that, the payments aren't $700 a month and they're almost 50% of your income or something. It needs to be a wise move. And that's more of an internal conversation between you and your attorney to just talk about, is this the right thing for us? We're going through bankruptcy. We're taking that negative hit. We're going to kind of move backwards a little bit and try to get rid of all the debt that we can. Let's try to be sure we set ourselves up for success after the case is finished. And part of that is, if I reaffirm the debt, am I going to have that debt to pay? Is it really going to hurt my budget moving forward? And that's a conversation that really starts by the attorney and the client talking about, what does this look like when we create your budget? We find that you can make this payment easily or not. Is it going to be a struggle? Are there other avenues for you to maybe pay cash or get a car later down the road? So that's your first, and that's probably the most crucial aspect of it. Now, if you decide to reaffirm the debt, then the conversation will go, depending on which attorney you have and where, what state you're in, the conversation will change a little bit, but it'll basically take the flow of, you'll reach out to the creditor, tell them you want to keep the vehicle. If you're current on it, they'll send your attorney a reaffirmation agreement. And that'll be the 8, 9, 10 pages that will re-up, and it will talk about the value of the debt, the percentage, the interest rate, the payments, all the things that need to be there. And then it'll talk about your budget. Can you make those payments? Can you not? And so that's what you'll review with your attorney, and then you'll sign it and send it back to that creditor, and then they'll either file it or your attorney will sign it, one or the other.
If the company, if the lending company says, oh yeah, we'll do it, but you know that 6%, you know, payment you're making, we got to make it 12%. Can they do something like that?
Well, here's the thing: you get a choice to sign it, right? And when you sign it, there's 2 different paths in our district. So it may change with what area of the United States you're in, and you definitely want to have that conversation with your attorney. But if they're looking to change the agreement, you know, that's not something that would happen in that situation. It definitely wouldn't be raised, because there's no way that a judge or an attorney would want to sign that if you're paying more interest. And conceivably, you know, the idea is maybe they have more risk, maybe they have, you know, these other couple of things, but it's a negotiation. And in this case, you're offering to put yourself on the hook for this debt in the future. And that has a little bit of leverage with creditors, because they want the money. They want to make sure they continue with the money, and they know they're going to make more money from you than they would if they just took the car back and then sold it at auction. So there's a little back and forth that goes on in there. Usually what you see in that reaffirmation agreement is that they either voluntarily or you kind of jostle a little bit and they lower the interest rate a little bit. You know, that's sometimes what you will see, because they know we're going to try to sweeten the pot a little bit for you to do this. It's less work for us. It's less work for you. We can all win here. And the smarter creditors will do that without really prodding. If they have a 12% interest rate coming in, they might knock it down to 6 or 7 just to make sure that it looks good for you and the attorney and the judge when they finally review that thing later.
So what's the downside? I mean, what are the risks? What happens if 4 months after the discharge, you suddenly can't pay on? I mean, are there risks involved? Because aren't you like reaffirming the loan after the bankruptcy is over?
You definitely are. And that's a conversation that you will have. In my office, we have that conversation multiple times. I have that conversation with them 2, 3, 4 times, because I want them to be aware. I want every client to know going into this that they're giving up something here in order to keep paying on the loan to keep this vehicle. So if you choose to do the reaffirmation and it gets to the end and it's signed by the judge, you have a window of time where you can change your mind. And the judges always like to remind you of that, and your attorney will remind you of that as well, that there's a window of time where you can change your mind. If you're outside of that window of time, you're on the hook for that debt now. So if you default, if things change in your financial situation and you say, hey, you know what, I can't make this car payment, or the car ends up breaking down or something happens, you're stuck to that loan. And of course you want to talk with your attorney in that case, because that's one of the offshoots, one of the worst case scenarios, really. And that's also why a lot of times when I speak with this to clients, I want to be sure that they understand signing this thing is the way for them to be on the hook for this thing a year down the road if they choose to change directions.
Yeah. You said a couple of times now, when the judge signs, does the judge have to approve this thing?
In our district, so in every district it may be different, and I can't speak to all the districts because I don't know all the United States, but you will, and you'll discuss this with your attorney. If you get into this, they're going to talk exactly what to expect as this process goes. But in our district, if the attorney signs it, then there is no court review necessary, because the attorney is saying this is in the interest. And of course the budget has to match up and things have to fall into place for the attorney to sign. If the attorney doesn't sign it, then it will be set for hearing, and it's a very brief hearing. But the hearing is really important, because the hearing is set up for judges to have an opportunity to chat with your client and just ask the client, can you pay the car payment? Do you need the car? Is this loan going to hurt you down the road? And their job is to sort of oversee, the protection of your interests moving forward, and making sure that creditor didn't just push you around. Maybe you're representing yourself and that creditor's been changing the terms, and they sent you a reaffirmation where they added $10,000 to it. Every once in a while you see something, something really strange like that. But the judge's job is to kind of oversee and to just make sure that you understand that you're on the hook for this if they sign it, that it's a lower dollar amount, that you can make it, that it's not going to hinder your progress financially down the road. And then they'll sign, and every once in a while, well, more than every once in a while, but the judge will have 20 people that they'll talk with. 8 of them, they won't sign the reaffirmations, but they'll give a speech. And their speech is something to the effect of, if I don't sign this, it's actually a good thing for you, as long as the creditor allows you to keep making payments and everybody stays happy. And there's case law out there that says, as long as people are current on their loans, that they can't have their vehicle taken anyway. So the reaffirmation really just gives the creditor something, but doesn't necessarily give the individual client anything. So in those cases, the judge may say, well, I'm not going to sign this, but if you keep making payments, everybody stays happy, nothing hurt, then a year down the road you default, you don't have to worry about paying for it. They can't collect on it, they can just take the car. And so there's some protection in there that the judges like to allow the people that go through that process. And it is legwork. It's not fun to go before the judge for a lot of people. They get nervous and they don't like dealing with it, but most of the time it's on the phone, and the judge is there doing a really important job to make sure they help to sort of oversee the process.
Going through the process and with an attorney, obviously, because as we've just come evident, there's a lot of ins and outs and nooks and crannies that you need to know about. So you're protected, but what about mom and dad? What about maybe someone who's co-signed this loan? How does either a reaffirmation or a surrender affect them?
A lot of different offshoots here, and most of what we talked to up to now have to do with just the individual that's filing the case. And so that's kind of where we were up to now. We talk a little about that co-signer, that individual that just came in to help you because maybe your credit wasn't good at the time, or maybe you couldn't get everything to work out so that you could get the vehicle. That person is not filing the case. And so in one way, sort of keeping your eye on what's going to happen with that person is important. If you file and you sign a reaffirmation and everybody stays happy with the thing, and you end up continuing to pay and you pay all the way down the road, then the creditor is not going to care. There is one change, of course, it'll show up on the credit report of that co-signer as protected under bankruptcy while the case is going on, because it is a debt that is protected under bankruptcy. And so there's a window of, hey, wait a second, we don't want to collect on the person who didn't file, because the person who did file on this loan is protected under the automatic stay, what basically stops everything in the bankruptcy. And so there is that kind of conversation that will happen of what happens with the credit report, and you will see it reflected on people's credit reports. And if it's accurate, it gets to stay there. So in this case, it would be accurate. Now, if you surrender the car, that's where the conversation changes completely. Because if you surrender the vehicle and somebody co-signed on that vehicle, then you are going to be, as long as everything goes smooth and happens in a normal way, you're going to be zeroed out for that vehicle. It's going to be considered unsecured debt, and it's going to, likely if you're in a liquidation at Chapter 7, then you're going to get through the process and that debt is going to go away for you. The car will go back to the lender in the perfect world. Sometimes strange things happen in that aspect too, but most of the time the car gets returned, dropped off, picked up by a tow truck. But then they sell it at auction, and then they assess a dollar amount. And however much the difference between the loan and the auction amount, added a couple of fees here and there, that can then be, it can't be collected on the person who filed the bankruptcy, but it can be collected on that co-debtor, that individual who co-signed for you, and they can go knock on their door and do all of the things that allow them then to go collect, garnish, lien, do all the things that they can do to get their money from that person who did not file. And so you always want to, family, it's usually a family member, and you usually have a conversation about what's going to happen with them, because you want everybody in the family to be happy, and you want to make sure you're representing the client fully. And part of that is making sure they don't go to their parents' house and have an angry parent.
Yeah. Yeah. It's like, you know, I have a personal attachment to this car. I love this car. I drove this car as a teenager. Well, it that doesn't take necessarily into consideration other people who maybe don't love that car as much, but they could be on the hook.
Yep.
So now, is this what we've talked about? Is this a chapter 7 uh, relief, or is it chapter 7 and 13, or is it a little bit mixed into both of them? Or is I got my car, I'm going to file maybe a chapter 13. What's going to happen to my car?
Yeah. The chapter 13 path is a little bit different, but it starts with the same nuts and bolts. So the idea is to keep it or to surrender it. If you keep it, you got to pay the loan or the value of the car, one or the other, depending on how long you've had it and what the situation is for that specific car loan. Okay, so the chapter 7 kind of has that same idea, and that's where we start with the blueprint. The chapter 13 has a couple of things that are different. One is, of course, the chapter 13 is designed to reorganize, to allow you to pay over time between 3 and 5 years, depending on what you qualify for. So it gives you time to pay off the car, and you can place the car into the bankruptcy and just amortize it, spread it out over 60 months if you want to. And that allows you just to pay the car loan, to say, hey, I might be behind in my car loan. And that's an important one, because in a chapter 7, in order to reaffirm, in the perfect world, you're current with that loan. And so a lot of times people will call me and they'll say, hey, I'm behind 4 payments. I think they're going to come take the car. I need to keep this car. And you say, okay, well, we can have this discussion, but can you catch it up in the first month? And if not, then maybe instead of a chapter 7, you look at a chapter 13 to get into the case, so that you can guarantee if you have the car, you keep the car. They can't come and repossess it once you file your case. And then your idea is to spread that payment out over time. And really the only question at that point is, are you paying the value of the loan, which if you've owned it less than 910 days, you need to do in order to keep the car. You pay the value of the loan that you owe them. And you'll pay that over 60 months if you want, in sometimes a creative fashion, but you got to pay the balance of it in order to keep the car. Or you can surrender the car and you can say, hey, I want to just hand the car back to them and do the same thing. That's an option in a chapter 13 as well. And sometimes people who have 2 or 3 cars, that's how we get rid of some of the debt that they may not want in their budget moving forward. And so that's a conversation. But there is one gigantic thing that you always want to kind of think about when you talk about chapter 13 and vehicles. And that is what they call a cram down. And I don't usually like to bog my clients down with the technical terms of these things, but what it means is, instead of paying the value of the loan, you're going to pay the value of the vehicle. So if you've owned this vehicle for 910 days plus 1, or a lot, you've owned it for a long time, you've been really tackling this thing, you've been trying to pay it off, it just hasn't gone anywhere. Maybe the interest rate's 20%, maybe it started at $50,000. Who knows? All the different things that come into play in real life. If you've had that in your situation, what we look at is paying a cram down value. And that value is the value of the vehicle. And so, of course, we have to be honest with it. Some people want to come to me and say, my car's only worth $1,000. I don't know about that. You have to get an honest number. But if you get an honest number, you pay that value over your 36 to 60 months in a chapter 13. And that allows you to move the interest rate and pay the value of it. So if you're underwater drastically on the vehicle, then you can get creative with how it's dealt with. Another thing a chapter 13 can definitely help with here is, if you came, let's say you traded your car in and you got them to pay off that loan, and then you got your new car. Well, there's some conversation there where that old amount that they paid off for that other car should zero out or do some diminishing in order for you to keep that car that you got from the lot on the trade-in, right? So there's a little play that you want to know. You don't need to know all of the deep parts of that, just that as that topic moves on, those are the bigger pieces that you discuss with your attorney to be sure that you're getting the best option as you go through the 7 or the 13.
What I take away from this whole thing is that there are a lot of different situations that can result in different decisions that you're going to make, and really needing to talk to an attorney about your situation and being honest and open about it. It's the only way you're really going to be able to kind of come to the answer you want. I mean, one of the things I was just thinking about is let's say you do a chapter 13 and you do a cram down. My question would be, well, are my parents going to have to pay for that extra part? I mean, there's just lots of different, questions that's what you're there for.
Absolutely. And the biggest piece that I tell clients before they get to the attorney, to that consultation, that opening conversation with the attorney, is try to understand. I mean, you definitely want to have the stats. And most clients will come to me and they'll say, oh, I've written all this stuff down. And that's great. That's a good thing to know how much you owe on the loan and what the interest rate is and when you bought the car, all the different stats, right? Those are the black and white. But the other piece is you might start to formulate the idea with what you want to do with the cars. What's your goal? Can the attorney get you to that spot that is your goal? And you want to make sure you have your goal. A lot of times I'll talk to clients and I'll say, do you want to keep that car? And I say this in every consultation when we talk about a car, do you want to keep it? Well, I don't know. It's, and then the conversation is longer because they haven't thought about whether they have an avenue to get other vehicles. And it doesn't necessarily mean, in chapter 7, people think this all the time too. They think that if you give your car back because they filed chapter 7, they'll never get another car loan. Oh, it'll be a long time before I can get a new car loan. That's not accurate. I mean, you get inundated by dealerships that will try to work you into a car loan very, very quickly after you filed a chapter 7. And so you have plenty of opportunities. Yes, the interest rate might not be glowing, but if you get a lower dollar amount, you get it, within reason, you can make that work. But it doesn't mean that you're done getting a loan. The conversation really starts though with the individual client just voicing what their goal would be with that vehicle and saying, hey, this is where I'd like to go. Can we get there? You can't always get them to that spot because maybe the facts don't lend to that, and maybe it's not good for them. But if you have an idea where you want to go, that helps the attorney to sort of create that path and the possibility and give you all your options so that you can see this is good, this is bad, how are we going to deal with this as the case progresses.
Wow, that's wonderful. Well, of course, we just blew through our time. And so before we go, this conversation we had, is this the kind of conversation, I'm assuming it is, that you would have with anyone who books an appointment and walks in and talks about wanting to get a bankruptcy? Every day
I have these conversations, and they're the general consultations. They're what you hear on TV, your consultation is free, that kind of thing. And that's exactly what we do. Everybody who calls, you don't have to worry about bringing your pocketbook. We're not worried about charging you anything, but we're also not giving you legal advice in that meeting either. So we're here to kind of tell you what pieces we think we can work with, what your options are, and give you that opportunity to go those directions. Usually about 30 minutes is all I need to work through those choices and figure out what may be best in the situation. And then if we decide to move forward, then we arrange how we're going to get that done and come up with a blueprint. So it is definitely something that we do all the time. You just have to call up and say, hey, I'd like to speak with an attorney. And you can ask for me, you can ask for any attorney at our firm. We'll be able to work through your specific situation and figure out what the options are and what, just counsel you on what we see as a good path for your situation.
That's wonderful. It really is wonderful. So Darin, thank you again. Once again, explaining, these bankruptcy issues that, are really complex, but you talk to them about them, and I can understand them. So it's just really a great option for people to have. And I would remind anyone else also that, give us a call here at Pacific Cascade Legal. We are happy to hook you up with Darin. If you want, you can leave a note on Facebook here and we can get you hooked up. So like he said, take advantage of it. And with that, everyone, thank you for joining us again today. If anyone has, again, any further questions, post it here. We can get you connected with Darin right away. And until next time, stay safe, stay happy, be well.